Did you find that application? So, anything mentioned in the advertisement like this? It's only what we showed your lordships, that the list of districts. No, that is there. It has to be there somewhere that you are applying for district ABCD. That form we have not annexed, Manoj. I'll have what form? It must be there in the advertisement only. The advertisement has an application form separately, which is not on record. So I have to give you the seated rules and the application form. These two things I'll have to place before your lordship. Right now it's not on record. If I may, after the other side finishes, I'll give your lordship that. This, you've given copies? This is of one candidate, Vinita Oro. This is from the Jharkhand Academic Council. Has qualified in the teacher eligibility test for the post of assistant teacher held in the month as detailed below. And language 2 is given as Mundari, which is one of the languages in that list. So this is an example, as an illustration. This one we have immediately. Just laser gun. So you want to convey by this? Yes. As per chapter 3, post and pay scales. Yes. It recognizes. Yes. The appointment at district level. District. And the influence of this district level appointment. Yes. Can be connected with that rule 7I and the 7I and J. You want to conduct what is your content. That's what I want to say. This appears to be. Yes, that appears to be. Finally, on the law, and the question is still to be answered is CTET. No. Yeah, sorry. CTET is fine. You have to. But my brother has asked in the advertisement, there is a stipulation where there is a stipulation that you should apply state. Yes. There is that stipulation, or in process of selection, if something had been issued guidelines, thereby in selection, when you will select those persons, then how you will arrange that name of the merit? Would it require to be arranged in accordance with the merit? Yes. And if it is so, then how without option can be possible? I'll respond on that. This is first question, then answer. I'll frame that. Now, if your lordship will just take that compilation of judgments that were handed up to your lordship by Miss Mona. Just the first one, my lords, is Devesh Sharma. Yes. Just please come to page 21, my lord. One of Devesh. This was an SLP arising from a Rajasthan High Court judgment which struck down the NCTE's notification which allowed B.Ed also. They said you can't allow B.Ed also. So para 63, Manoj, at page 21. If I may read that. In Society of Unaided Private Schools, this court, while upholding the... I'm sorry, Manoj, Justice Bindal held? Yes. This court, while upholding the validity of the RTE Act, held that primary education, which is now part of fundamental right under Part 3, Constitution, has to be a meaningful education and not just a formality. When diploma in elementary education was placed as an essential qualification for teachers in primary school, it was with a purpose, and the purpose was to declare only such teachers as qualified who are trained to impart education to children at primary level. The pedagogy for a child who has just entered the school is an important consideration. A child has come to face a teacher, so to speak, for the first time in a classroom. It is the beginning of a journey for the child student, and therefore, world over, great care is taken in laying down proper foundations in these formative years. Well-qualified and trained teacher in elementary school is an extremely vital aspect. A teacher must be trained to teach students at primary level, and this is precisely what the training of DLED does. It trains a person to teach children at primary level. B.Ed is not a higher qualification or a better qualification as is being canvassed in its favor, while comparing it with diploma in elementary education. If your lordship can skip the next few pages which are peculiar to the DLED issue. About 4 lines down on page 22. This defeats the very logic. This is about having a 6-month bridge course along with the B.Ed to bridge it. This this defeats the very logic of including B.Ed as a qualification, as the very notification which pushes for the inclusion of B.Ed also recognizes its inherent pedagogical weakness in its relation to primary classes. This is precisely what the High Court has done in this case, saying within 6 months you will have to qualify. It is to cover this defect that all such candidates must undergo a mandatory 6 months bridge course in elementary education, exclamation mark. The irony here is that all this is being done when the state of Rajasthan already has more than the required number of diploma qualified candidates available. This is besides the fact that there is presently no such bridge course available. At least there was none till the disposal of the petition by the Rajasthan High Court. Next paragraph. Under these circumstances, we are unable to comprehend as to what was the pressing need to include B.Ed candidates who are admittedly not fully trained to take up primary classes. Consequently, the decision of the NCTE to include B.Ed for teachers in primary school seems arbitrary, unreasonable, etc. I am adopting this reasoning, my lords, for what the High Court has done. Online candidates are available, this or not. But again, in that compilation, the last judgment, because your lordship put a question just now about advertisement being the starting point of the selection process. So the last judgment there, my lords, is Devan Katti at page 43, my lords. Just see para 11. Yes, para 11. There is yet another aspect of the question where advertisement is issued inviting applications for direct recruitment to a category of posts, and the advertisement expressly states that selection shall be made in accordance with existing rules or government orders, and if it further indicates the extent of reservations in favor of various categories, the selection of candidates in such a case must be made in accordance with the then existing rules and government orders. Candidates who apply and undergo written or viva voce test acquire vested rights for being considered for selection in accordance with the terms and conditions contained in the advertisement, unless the advertisement itself indicates a contrary intention. Generally, a candidate has right to be considered in accordance with the terms and conditions set out in the advertisement, as his right crystallizes on the date of publication of advertisement. However, he has no absolute right in the matter. If the recruitment rules are amended retrospectively during the pendency of selection, in that event, selection must be held in accordance with the amended rules. Admittedly, the rules are not amended retrospectively, the present rules. Whether the rules have retrospective effect or not primarily depends upon the language of the rules and its construction to ascertain the legislative intent. The legislative intent is ascertained either by express provision or by necessary implication. If the amended rules are not retrospective in nature, the selection must be regulated in accordance with the rules and orders which were in force on the date of advertisement. Now, this has been followed recently. This is a 2-judge decision. It's been followed recently, give copy, by a 3-judge decision in Assam Public Service Commission. This is 2020. I'm sorry, we don't.
This is also on record here.
No, my lord.
It is there.
Assam Public.
Serial number 2.
Yes. Oh, so sorry.
Yes, she has already read it.
So it's been followed for the same. Just paras 15 and 16.
Yes, she has already read it.
So it's been followed, and that's a consistent position. That date of advertisement. One small thing on facts. The date of the advertisement is 19th July 23. Now the advertisement itself gives for the last date of application 7/9/23, and last date for modification of the application is 15/9/23. Even if we were not to take the date of advertisement as when selection process commences, at least the last date
Submission of application.
last date of modified application 15 September 23. By then, no amended rules had come. Impugned judgment had also not come. Impugned judgment, which is in December, becomes the basis for the January new rules coming. So there was no question really of extending a date once the date is over and done and the process is complete, in my view. So even if it's not date of advertisement, even a later date, it doesn't come by then, and it's not retrospective. I'm grateful. Thank you. That is all. We'll respond on those 2 points your lordship mentioned.
Go find out. Yes, please, Mr. You are for the government.
For the government in the first matter, lords.
First matter.
Not for the there is a different in 2 matters. The state will remain the
There is no difference is only the functioning of 2 engines.
Double engine. We are trying to make ourselves an engine.
No, double we are not saying intentionally. 2 engines.
So that,
So that you can understand, we will not explain why 2.
yes,
And what is the purpose.
But I must confess, my all colleagues, we sat down together, to prepare a list of dates, but even with your lordship, no consensus. No. With your lordships, every question today, I pick up the list and see whether there is a date there or not. And I come to know, that there are 2 rules, with which your lordships are dealing. One is the recruitment rule, the other is the TET rule. So, every time with the help of, my friend and my friend here, we are finding that there are so many notifications in both the rules, which have come after filing of counter, etc., or even before that, which are not before your.
They are not interested in after filing.
Only relevant, only relevant.
They are not interested in after filing of the counter. We are only concerned whatever is prior to that.
Only on that basis,
And the another question is, what is the first rule is there, already there. So where is the import of issuance of notification? Is it circular or it is an amendment in the rules?
There is an amendment in the rules.
In the rules. So prior to that, on the 11th, I not reader.
I have to first of all answer your lordships on the question which have arisen with regard to section 23 of the Act. If your lordship is right, I am able to satisfy on that answer, my lord. Yes. And most of the other questions, my lord, in my respectful submission may get answered. Kindly come to 23 straight away.
We will come to that.
Because, my lord, your lordship will just keep 2 things in mind.
RTA.
There is a TET rules, first of all, recruitment rules and TET rules.
Whatever you want, we will say.
I am only my respectful submission that 2 rules which are applicable in the present case have some play. One is the recruitment rules, other are the TET rules.
So what is to be seen first?
First of all, the Act 23. Yes.
23.
Yes.
So you want to get out this?
No, I want to get into this with clarity, to myself. I don't want to get out.
You are clear.
We once enter the portals of the Supreme Court, we never want to get out. And we have the privilege on this side, we can choose a date of commencement or the last date. Both followed. Commencement as well as kindly come to 23 straight away. Your lordship has seen the
And application of rules as per your choice.
which followed will be decided by your lordship.
In the context you are saying.
Yes, Lord, in the context. Unless the context otherwise requires, Lord. Now, Lord, your lordship has seen the definition of school as well as the appropriate government, your lordship.
So by this time, you did 20% rule. Deviating from the thought process which have come from the medical side. So 20% rule you have discharged.
But gradually you will remind us, no?
This fits with the situation. This is we have some to calculate the matter for the client that instead. So he said, "Oh, my friend said, oh, you can't claim that." Other side, when you open balance sheet, they have so much of money. What I'm saying is that was before the education.
Now it is plus 10%. 30%.
The rest will be played by Mr. Guru.
All right.
100% flat. 23-1.
Yes.
Qualification for appointment and terms and condition of service of teachers. I am not going into other issues which are not relevant here, my lord. Primary education, higher education, central government gets priority under entry 66, not relevant here.
That's not the issue. They have not argued it.
Here, I am not even raising it. This right to education 23-1 and 23-2 and 23-2, my lord, if I am right and persuading your lordship, my lord, the answer is in 23-2, which would resolve a number of issues. Any person possessing such minimum qualification as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. No, so far so good, no problem. When we come to 2, there are 2 extremely relevant nomenclature in 23-2. And the relaxation for that vested in the central government is only for 2, which never includes state.
Alright, that is.
Where a state does not have adequate institution. Because, my lord, after the NCTE, it is the approval of the NCTE for all those colleges, my lord, who can legitimately and in a recognized manner grant education in the education courses like B.Ed, etc. So NCTE approves all of them. That is the body created under the NCTE Act. They will not decide what is the on what parameters a particular institution impart that education will be recognized. Where a state does not have adequate institutions offering courses or training in teacher education, pre-market two things. Offering courses or training. That is neither a course nor a training.
What is neither a course nor a training?
It is, I'm going to show to you.
CET, you say, is not a course.
It's only a eligibility test like a CTET. Like a common, it's not exactly common entrance test, the old common entrance test.
Common entrance test is a different.
But that is not a qualification or training. It is neither a qualification or a training. And I will make that good because it is provided in the rules and there is one judgment of your lordship. Let me repeat this, I wish to read it with your lordship permission again. Does not have adequate institutions. So this is the legislation.
There are three words used.
Yes, my lord.
Adequate institutions offering courses or training in teacher education to
or teachers possessing minimal qualification as laid down under subsection 1 are not available in sufficient number. The central government may, if it deemed necessary by notification, relax the minimum qualification requirement for appointment of teacher, but for such period not exceeding 5 years as may be specified in that
this
notification.
is one of the qualification prescribed.
One of the qualification prescribed is, my lord, they are
It is the prescribed qualification or not? Then how do you say it is not a qualification?
No, my lord, the qualification in the course.
We can understand.
What kind of level of the qualification?
So, Mr. Madhendra, we are not that much. We want to understand the issue. The emphasis is where a state does not have adequate institution offering courses. One part.
In teacher education.
Please.
In teacher education.
Please kindly. Go separately. Where a state does not have adequate institution offering courses or training in teacher education or teachers possessing minimum qualification as government may, if it deems necessary. So, this is all three adequate institutions. This is one. Here it should be a comma. It should be a comma.
Let us proceed on that basis.
Alright. It should be a comma. Then come to the point. Offering courses or training in teacher education or teachers possessing minimum qualification. Then as laid down.
May I respond, my lord, straight away?
So this is like this. We have to read like this.
Sir, with utmost respect, there would not be a comma, my lord, with utmost humility. Why? For the reason why.
No, it is just I'm not understanding. Nothing not for humanity or this is not.
I'm responding. I'm
For
responding.
only introduction.
Yes, for only in that spirit, my lord, I'm responding. The state is not having something which is that education institution it does not have. Education institution is a common word both for course, that is, state does not have adequate institution for imparting education or offering courses in the teacher's education, that is number one. Number two,
Not in the or is there before that.
I'm answering that. Now, please read it again. Adequate institutions
Offering courses.
I stop here. I stop here.
Yes.
And now read it again.
Not and thereafter or is there.
I'm coming to that. Just for me.
You are using and.
No. Now kindly see the first. I'm only categorizing it two. What is the meaning of this?
Yes.
State does not have adequate institution is common.
Yes.
Right, my lord? Adequate institution for what purpose?
Yes.
Two different classes. One is offering courses. So state does not have adequate institutions who would offer courses in what? That courses are in the line below teacher's education. It's not the science course or a medicine course. It is teacher education.
Why the word or is used?
I'm coming to that or.
Yes, come to
Then, my lord, there are institutions who also offer training. They are not.
too far-fetched.
No, my lord, now kindly, utmost respect, my lord. The does not have adequate.
You want the section to be rewritten.
No, my lord, I am not doing language. I am not doing that at all. I am only saying, my lord, that is not a part of this particular provision. I'll show to your lordships how. If your lordship may have, my lord, it is so, my lord, because the scheme, statutory scheme is that it has also stood accepted in the rules. The 2019 TET rules specifically.
All right, we take it as you are saying.
Yes, my lord.
We take as you are saying.
Correct, my lord.
Please go ahead.
Now, my lord,
Please go ahead. I will put a question then after the
yes, now, what is the sequitur of that is, if a state does not have institution who can offer courses in the teacher education, number one, or does not possess adequate number of institutions who offer.
Your intent is offer courses or training be read conjointly. Either offer courses or training, then in teacher education.
Well, teacher education is common.
So teacher education, what do you mean by teacher
In
education?
teacher education, they are offering courses, and also for the purpose of teacher education, there is a training separately. So there are institutions who offer.
So this doesn't cover TET. You want to say this?
TET doesn't fall under it.
You want to say?
Yes, well, that's why this is full submission.
We can understand.
Let me repeat for my benefit. Let me repeat.
No, certainly.
Lord, the first thing is which your lordships have to see is the legislative acceptance that whatever scenario is existing in the country, there are states where when you lay down the NCTE standard and the B.Ed courses, the adequate institution would be those who are recognized by the centralized authority.
Yeah, that is it.
To impart that course or a training. Therefore, if that is the situation, you have to meet the requirement of the state for primary education. So therefore, for a maximum period of 5 years, the relaxation for those conditions can be granted, but that authority is vested in the central government. Now, my respective submission is, my lord, if your lordship now come to, my lord, that additional document, page 11, where your lordship has seen the advertisement. Just have a look at that, my lord.
No, we'll go to that. Yes, the complete the rule.
I'm only on that. Only on that I want to take a stance on
All right.
that argument. Just keep it with that, my lord. Section 23, keep it with page 11 of the additional document where your lordship has seen the advertisement. Page 10, it starts, my lord, page 10.
Yes.
This is the notification of 23rd of August 2010, my lord. I'm sorry, my lord, this is not advertisement, this is the NCTE rules, my lord, or 20 notification of 23rd of August 2010.
Describing qualification.
That is coming to page 35.
I'm coming to that, my lord, yes. Page 10. Minimum qualifications. Right, my lord?
Is
Page 10, my lord. Minimum qualification number 1.
yes.
Then, my lord, your lordship will see small Roman I classes first to fifth.
Yes.
Now, please see the first A. Senior secondary for or its equivalent with at least 50% marks and 2-year diploma in elementary education, whatever name known. Right, my lord? This is 1. 2. Or. Senior secondary or its equivalent with at least 45% marks and 2-year diploma in elementary education, whatever name known, in accordance with the NCTE recognition norms and procedure regulation. So there, my lord, your lordships appreciate, my lord, the recognition concept by the centralized authority, the regulatory authority, NCTE institution that is recognized by them. Then, my lord, senior secondary for its equivalent with at least 50% marks and 4-year bachelor of elementary education, senior secondary or its equivalent with at least 50% marks and 2-year diploma in education, special education, and so or is gone. Or is the option in the educational qualification of a course. It is neither a course nor a training.
Yes, please.
It is answer.
Yes, please. Can we read the rule again?
Senior second, I am starting.
Minimum qualification, class 1 to 5.
Class 1, class is 1 to 5. Senior secondary or its equivalent, that is 10 plus 2, my lord. With at least 50% marks and a 2-year diploma. My lord, your lordship, know in education, teachers for education, my lord, they are diplomas and B.Ed. Right, my lord? So one is this diploma, you must have 2 years. First of all, you have 10 plus 2 with 50%. Then you do 2-year diploma. And then, my lord, a 2-year diploma. And then second choice is senior secondary, that is 10 plus 2 or its equivalent, with at least 45% marks. Supposing I have received 45% marks, I have not received 50%. And 2-year diploma in elementary in accordance with NCTE recognition norm and procedure regulation. Or senior secondary, that is 12th, with at least 50% marks, and 4 year of bachelor elementary education senior secondary with at least 50% marks and 2-year diploma in education, special education. And then, my lord, it or is gone and comes.
Yes.
And now permit me to read.
Yes.
My lord, 10 plus 2 is an education qualification of a course. The 2-year diploma is a course. B.Ed is a course. This is neither a course nor a training. I read it, my lord. Pass in teacher eligibility test to be conducted by appropriate government in accordance with the guidelines framed by NCTE. And my lord, now read with this, which is, my lord, otherwise the position in the 2019 rule, which is in the counter affidavit. Just keep both of these documents here. Kindly see Rule 11.
Rule 11.
Rule 11 of the 2019 rules update. We start at page 21. There also, my lord, we have to update. There are various amendments made.
No, Mr. Maninder Singh, we can understand whether this stand have you taken ever in the High Court? Whatever you are making here,
No, my lord, take
observations.
this is not
the stand taken.
Let us
But
understand.
saying where they don't have a case and you had
Mr.
to.
Maninder Singh, we can understand for the purpose of interpretation, something can be done. Alright, this is one part. But at least you must have come out with a case. That please listen. So far as this qualification part is concerned, whichever you are saying, that is not required, and their contention relying upon 23 would not be good because of in section 23 it doesn't specify like this. And even then, the government stand is like this. We can understand your argument is fine.
I have understood your lordship question. Please permit.
And you made the amendment in the rules. You also understood this all is applicable.
No, my lord.
No?
My lord,
But for the amendment was required if this is not the qualification.
3(2) is to be applied. Amendment can't be made by a state government. With utmost respect.
State only made the amendment.
Because we are entitled to amend the TET rules and our recruitment rules.
All right.
Governor, I answer it.
All right. That also we'll see.
No, my lord,
But where is that stand in the written statement?
that's what I'm trying to answer your
So
lordship.
you never let the High Court examine any issue.
Your lordship's are questions are, my lord, straight to me, which must be answered, my lord.
We are asking a question. You please go by what your stand before them.
My lord, I will
First start by that.
My lord, the prayer be relieved.
No, relieve me. Please, what your stand before the High Court? Come with your WS. That is written, counter affidavit. Please come. Mr. Maninder Singh, don't go out of that.
My lord, I
No,
will.
he will not need more than that.
My lord, I stick to the pleading.
Please come to the pleading, where this pleading is there.
Yes, let us see, my lord. For that, my lord, I have to show your lordship the writ petition, what is the case pleaded. Now let us see the writ petition. We have a writ petition. Show me.
Which page?
268 in the writ, the SLP paper.
268.
Answer 268. Come to please, my lord, your lordship kindly come to 268.
If you never argued all this, the AG conceded. That's all on his
My
questions.
lord, I am duty bound to answer every question of your lordship.
Certainly, sir.
The AG statement followed by the subsequent rule is a matter of record, and that
Do not say matter of record.
is recorded in the judgment.
That's there.
Yes.
But the AG never said so. Despite the reply that they don't have a case, the AG said, all right, we'll consider them eligible.
Kindly see, the prayer is of CTET.
Yes, yes.
Inclusion of that CTET. CTET has nothing to do with 23.2. It is not claimed on the basis of 23.2.
That we have not come to that.
Lord, I show you what is the
You discuss that. Please let us understand your claim.
They see the writ and the counter first. Let us go to the writ. I will try to find out, Lord, is there any foundation that you have no jurisdiction at all? The other
Case
side.
initially was not that.
Lord,
The case initially filed before the advertisement.
Yes.
It said you are not holding any test.
Because, Lord, there existed. One is not holding the test because
Yes.
are not end up.
And then they said you make them eligible, that's all.
You're not right. 2016, after 2016, unfortunately, state has not carried any whatever is after that. The recruitment which is to take, and your lordship is absolutely right, the writ petition is filed before that. Because till that time, it is only JTET which was making the candidates eligible.
You did not hold any recruitments from 16 onwards.
But 16, nothing has happened. 16 is frozen. My lord, your lordship is right. Both, my lord, for the purpose of recruitment as well as holding of a TET.
All right.
Right, my lord? Your lordship is perfectly right, my lord. When this writ petition is filed, as per the existing rule, there is a condition of JTET to be possessed by the candidate to become eligible for any recruitment process to be held by the state for teachers. The writ petition is filed first by the candidate who are possessing CTET. They are not saying that under 23.2, CTET has to be included because that is the domain of the state. Kindly now see what is the basis of the writ petition. First, my lord, absolutely right. At page 272, the TET is not being held. Now, my lord, kindly see page 275 where reference is made to the TET of 2019. Page, my lord, 275. There are two sub-Roman I, where, my lord, with reliance on Rule 12 of TET rule that you will hold the exam annually, is referred to, my lord.
2019 the rules were framed.
Your lordship, with the rules which your lordship has seen in the counter page 21, they are TET rules of 2019.
Right.
In that rules, my lord, JTET is the TET where clause 12 of the rule says the state will conduct examination on regular basis annually. That has been referred to, my lord, in subclause Roman 1 of para 2,
Yes.
which goes up to 276 and refers to rule 12 on the top, my lord, second line. Rule 12 of the aforesaid rules.
Yes.
My lord, page 276, second line on top. Rule 12.
Yes.
Then, my lord, your lordship will see that sub-Roman 2, that has not been held by the respondent, particularly when there is a guideline of NCTE conducting teachers' eligibility test to conduct a TET in every year. That letter of this, my lord, the NCTE is 11 to 11, which is relied upon. Then kindly come to, my lord, then your lordship can skip. 279 bottom Roman 6.
Note that for last 6 years.
Yes, my lord. And then, my lord, if your lordship may kindly come to the recruitment rules, which is, my lord, referred to in sub-Roman 8 at 281. Which, my lord, these rules are, my lord, just here something is relevant, which, my lord, my friend had instructed me to take that as a preliminary submission, but I said, state but discharge its owner to answer. My lord, 2012 rules were substituted by 2022 rules. Under 2012 rules of recruitment for
There is one question. Again, same thing. They filed a writ petition, pleadings are there, whatever is there before the advertisement. You are contesting that. With reply also, with argument also. All of a sudden a stand is taken that we concede there.
if you are
To that means pleading or no pleading, you had conceded everything.
if the state in a given circumstances with the enabling provision and a policy, my lord, is
Not your stand.
I'm on my stand. I'm on my stand of the
You are standing, that's all right.
my stand, my lord.
Your stand is all right. Where is your stand in the reply?
My lord,
Yes.
my lord, my respectful submission is this, my lord. NCTE has taken to some extent the state's autonomy to the extent which is permissible for the primary education is not taken away. NCTE predominance has come. Everybody must follow that for complying the scheme of
Standards laid down.
standard laid down, right? In that laying down the standard, the central government role for exemption or concession or relaxation is not for any norm of that. Is not for any norm of that. It is for the state to decide whether they are permitting CTET or not.
Please come to here.
So, Malad, if the state
Let us understand you are coming on the pleadings of the
Malad clause
then come to the pleadings of the WA
81.
and come to the pleadings of the WA
I will.
then come to your stand before the Supreme.
Yes, Malad. Supreme Court as well as Malad in the High Court we filed two affidavit, original affidavit and then supplemental.
We are ready to.
Yes, Malad, kindly see 281 2022 rules of recruitment. Now, what I was explaining was something important which has not been informed to your lordships. 2012 rules had not provided for any entrance test for teachers by the state. It had not provided. On your qualification, some kind of a weightage used to be given, and then you would get selected. They challenged 2022 rules, the same set of petitioners, before the Honorable High Court, that you cannot now convert this 2012 no test to a test now. Test for recruitment. They filed a writ petition. This petition stood rejected, where they challenged the 2022 rules. And the same advertisement which was put in, the advertisement is challenged, the rules are challenged. But the High Court rejected it 9th of September, where they wanted to rely on this petition. I am informed, I am instructed, I was not appearing. This Honorable Court has dismissed.
Suppose the rules of 52 were challenged and
And the advertisement is also challenged.
advertisement when issued.
July 23 advertisement.
So how it can be challenged? The rules when it was challenged.
Malad, the rules, the 23, the advertisement is issued.
There was a separate writ for that.
Yes, Malad, by the same set of petitioner.
Maybe of that makes any
No,
difference.
I am so Malad, only as a
They are not making a difference.
Malad, they kindly see the prayer building.
We can come to a different point.
I will, yes.
You are saying that 22 rules along with the July advertisement, it was challenged by the same set of petitioners, and the challenge was to the rules. What were the rules and the challenge in that?
Rules of 2022.
What was that particular rule and the challenge?
You have mentioned so in your counter affidavit.
Counter it has been mentioned.
In Supreme Court.
That they, no. I can access the Supreme Court or just
No interference.
Supreme Court order is on 9th of September.
No, that's right, but did you
High Court
mention?
order.
Yes. Did you mention in your counter also
What did mention?
that they filed this writ petition dismissed and the matter is pending before this court?
No, the High Court order you must be aware. It's not there in the counter, Malad.
Dear side, we want to understand a different thing. Writ petition filed challenging the rules of 22. Which rule was under challenge? Number one.
The entire set of rules as ultra virus.
Entire rules can be
They are incorporated in the order.
No, we can understand what is there.
Let's have a look.
And then one thing,
Yes.
and the another is advertisement. Which condition of the advertisement was challenged? And
Meenakshi would have
suppose
Because they had challenged the entire rules and the entire advertisement on this ground that because the 2012 rules are prevailing, they should get direct appointment. They should not go through this process, which is subject matter here, saying that they should get direct appointment because they have been waiting.
Also states that the presently they will have taken examination. So here in the examination, 22 groups they have taken examination for appointment. They wanted to overreach that 22 groups to say that
what is the relevance of that even? Maybe that as per rules. At present, 22 rules are in vogue. 22 rules, as per 22 rules, whatever is read over, for the purpose of qualification, for the purpose of entrance test, it is not in dispute. So once it is not in dispute, then even they had challenge for that. And whatever the decision is dismissing that petition, what may be a consequence to the present point. There may not be consequence of present point. We'll see, we'll look into left. Let Mr. What is the relevance of this? Mr. Maninder. Mr. Maninder Singh, please.
Kindly see, my lord. Page 281, I was showing to your lordship the two
Yes, please.
for reference to 2022. Then, my lord, your lordship may kindly come.
Yes.
Para 8, my lord, that the state is not conducting TET after 2016.
All right.
And then, my lord, if your lordships may, in continuation of that, kindly see para 7, 286. 286 para 7. It is relevant to state and submit that the petition number 2 is the mother of one of the aspirant who is willing to participate in the selection process in the state but cannot do so because of the mandatory requirement of JTET qualification whose examination has not been conducted since 16. The petition 2 has come across several number of candidates who possess all the requisite qualification to be a part of selection process, but the state has made JTET as mandatory. It is not being conducted state for last 7 years. And then, my lord, if your lordship may kindly come to the prayer. Page 289.
Page 289.
Last 3 lines, my lord, prayer A. For showing cause respondents, teachers eligibility examination the state since the year 2016, in spite of regular demand and protests of large number of affected candidates, which is not only creating chaotic situation in the law and order, but also amounting to ruining the aspirations of poor students who are merely aspiring to participate in the process of appointment for the post of teachers, which very much requires a candidate qualified as mandated under the provision of the National Council for Teachers Education Guideline, as per which such examinations to be conducted on yearly basis. But unfortunately, no compliance by the state respondent gross violation of the guideline of NCTE and the rules of 2019, which are the TET rules, where also the stipulation is contained that you will conduct it regularly.
But if we read this in true sense and spirit,
Yes,
then these petitioners have stated that as per NCTE, under RTE, NCTE is the authority which shall prescribe minimum qualifications for the purpose. They admit this part. TET is mandated under the provisions of the National Council of the Teachers Education Guideline, as per which such examination is to be conducted on yearly basis. Alright, this part they are admitting for the purpose of examination because this relief leads to the holding of that examination. How come to be?
for showing cause is also how they will address the aspiration of large number of candidates available in the state of Jharkhand who have acquired all other requisite qualifications for participating in the process of recruitment of teachers in the state other than having the mandatory TET qualification only because of fault and latches on the part of the respondent who have neither conducted the TET examination since 2016 nor have they taken a decision to recognize CTET
So
qualification.
here they say recognize CTET. How come to next?
For directing the respondent to either conduct the teacher's eligibility test in the light of the Jharkhand teacher's eligibility test examination rules published, notification number so and so, which mandates the state authority to conduct the TET examination every year and oblique or to consider the CTET qualified candidate worthy for participating in the selection process of the teachers in the state as per the policy of 2011. Now, my lord, this, if your lordship may kindly see, there is no argument of any 23-2. The only argument is that the NCT prescribed
What they are asking there before the writ court, they are asking that we are aware CTET is not the qualification prescribed for the teacher's test in the JTET, in the rules of 22. So, please, number one, hold the regular test as per 2019 rules. Number two, or CTET may be
included for eligibility.
included for eligibility. Now, for that purpose, we have to look into what is the answer of the state.
Surely, my lord. But what I am the yes, my lord. Your lordship may kindly come to the counter. 295.
Yes, please. Please, where we have to look into?
My lord, 295 it starts.
Yes, please.
Kindly come to 297 bottom para 7. Here, my lord,
You have taken it as a public interest litigation. So you said it is an instant public interest litigation was filed for the following reliefs.
yes,
Alright, then you have referred to the release.
yes, my lord.
Then you have started answering so and so. That is stated as submitted without para-wise reply.
301, my lord.
Yes.
One. Kindly see para 10.
No, first line. You recognize RTE Act.
No, but that RTI nobody can run away. I know that the
We are only referring, Mr. Maninder Singh, we are not saying
yes,
anything.
RTI active
Say what appointment as a teacher in any of the school referred in clause N of section 2 of RTE Act, he or she should possess a teacher's eligibility test,
Yes.
which will be conducted by appropriate government in accordance with the guidelines framed by NCTE.
So that is
So for the answer one part, this is next.
10.
Come to 10.
It is stated that therefore the respondent is serious in implementing the provision of RTI in its true spirit and letter, for which various consultations carried out by the respondent with different stakeholders. Better implementation of TET objective after looking to geographical and regional needs and requirements such as various languages, tribal cultures, Hindi language speaking, population difficulty before conducting a fresh CTET examination in the state of Jharkhand.
Yes.
Para 11. That the COVID-19, my lord, your lordships can skip.
Alright.
12. So far, CET exam is concerned, center teacher eligibility test is conducted for determining the eligibility of the candidate for post of 1 to 8 in central government schools such as NVS, KVS, and other schools which does not fulfill the needs and requirement of the state, regional languages, and other local needs, and whether to consider CET qualifications as equivalent to JTET in the matter of policy decision. Then, my lord, your lordship can come to para 15.
Yes.
Respondent in the process to bring necessary amendments in the JTET exam to bring it on the quality and standard of CTET level. It's most humbly submitted that the respondents are going to bring some necessary amendments in the JTET rules which is
No, rule kindly para 13 is also written.
yes, for 13 I read.
It is most humbly and respectfully submitted.
Respondent said it is in the process of framing a rules for conducting fresh TET examination in the state of Jharkhand, which is under process, and due to which much time has passed for conducting TET examination in the state of Jharkhand. Then, my lord, 14, once the rules will be framed, it will be sent for cabinet.
Then 15.
15, the respondent in the process to bring some necessary amendments in the JTET to bring it on the quality of CET test. And, my lord, it's most complete and submitted that the respondent going to bring some necessary amendment which are under process. Stated that the circumstances there are misconceived. So, my lord, what the state response to
Only TET, about TET you are telling.
only about TET, because the prayer is only for TET. Conduct of TET or CET we permitted.
Eligibility also.
It's a eligibility test.
Alright. Please go ahead. Go ahead.
But then,
And one thing you admit here, there are 15.
yes,
The respondent is under process to bring some necessary amendments in JTET exam to bring it on quality and standard of CTT. That shows that your standard is lower.
what happened is,
This is what you are saying.
but it's the standard of CTET for central schools and other schools
Is higher.
does not necessarily mean whether the standard in the state may be lower. But yes,
This is what you are saying.
it's always an aspiration, my lord, that you must also be in that my lord, pedestal where you can say, I am as good as anybody else. But that does not mean, my lord, that I am not meeting the requirement of minimum.
That you have to accept that somebody is above.
Of your stand is, it indicates that further respondent is under process. Necessary amendment in JTET exam
Yes, my lord.
to bring it
Yes, my lord.
on the quality and standard of CTET level.
Correct, my lord.
What does it mean?
My lord,
Your exam and the rules are not at par to the CTET, so you want to brought it to the CTET
your
level.
lordship may also read it with para 12, my lord.
Yes.
Read.
12 if your lordship may permit.
Yes, read.
So far as CET exam is concerned, CET test is conducted for determining the eligibility for teachers for classes 1 to 8 in the central government schools such as so and so, and other schools, etc., which does not fulfill the needs and requirements of state, regional, language, and other local needs, and whether to consider CET qualification as equivalent to TET in the matter of policy decision. We followed is the clause 10 of NCTE, and clause 10 made it only enabling for.
Please go ahead. This is not. Go ahead.
Clause 10 I have to come
We
here.
consider we will not looking to on that. Come go ahead.
Yes, my lord. So this is the reply which is given, my lord.
No, please go further.
Yes.
Further reply.
Para 16.
Yes.
It is submitted that the respondents are going to bring some necessary amendments in the JTT rule which is under process.
So this is you said this is misconceived. Then rejoinder affidavit.
This is not applying to the
Sir, dear, anything about that point that the CTET must be made applicable or not? You said merely said one line. It's a policy decision.
No, I say something else, my lord.
So this is the first counter affidavit.
Yes, my lord.
Which is another counter affidavit.
Yes, my lord. Let me show the second counter and then make my submission.
Yes, please.
Supplementary affidavit. 300 and my lord 15.
315. Supplementary counter affidavit.
Yes. It starts at my lord 314. And then my lord, your lordship may kindly see. Para 5 at 317.
No, there is some order of the court.
There was an order of 15/7/25/7.
The petitions were
Which is that order?
25/7 order.
The import of that also.
25/7 order. Yes, that is what your lordship seen yesterday that the writ petitions were filed before the admission.
No, that's right.
You want to see this order of 25/7?
Yes, yes, I'll just give it to your lordship, no, that order.
Where is this order? Page 58 of
The counter affidavit.
Supreme Court counter affidavit. Supreme Court counter affidavit दी थी. Supreme Court का counter affidavit.
It's page 15, 15. 58, my lord, I'm sorry, page 58. Same, my lord, where your lordship has seen that tax rules. Same volume. In the course of hearing, at page 58, my lord, if your lordships have got it.
Yes.
In course of hearing, learned senior counsel, Sri so-and-so appearing for the petitioner in the lead case, would draw the attention of court to clause 10 of the guideline for conducting TET which is provided at subclause 2. I'm sorry, not your lordship, just in my statement. May I read it from?
Yes, please.
In course of hearing, learned senior counsel appearing for the petition in the lead case would draw the attention of the court to clause 10 of the guidelines for conducting TET, wherein it is provided at subclause B that a school referred to in subclause 1 and subclause 2 mentioned therein may also consider eligibility of a candidate who has obtained TET certificate awarded by another state UT with the legislature in case a state government UT with legislature decides not to conduct a TET school at 1 and 2 in the state UT would consider the TET conducted by the central government. We are of the opinion the state government is genuinely creating a number of posts for which state TET examination required to be conducted, which has not been held at least for last 9 years. The examination was held in 16. Then it should take into consideration the said provision. We advise the state to file a short affidavit stating whether they intend to allow these candidates who have obtained TET certificate from the central government.
Now read your counter.
Yes, now kindly see come to para 5, 317. 317, para 5.
Yes, please.
The reference is made to this order, my lord. So your lordship can skip para 5, para 6. It is submitted that before going into the query, it is necessary to bring a factual aspect for proper adjudication. One of the essential qualification of person to be appointed teacher is referred to in so and so is RT Act is that he should pass the eligibility test of TET. which will be conducted by the appropriate government in accordance with the guidelines framed by the NCT. It is stated and submitted that state of Jharkhand is intending to implement the Jharkhand TET objectives in consonance of the geographical same thing with regional need requirements such as various languages, tribal languages, culture and Hindi language speaking population within the state of Jharkhand. It is most humbly submitted that the central teacher eligibility test hereafter referred to is basically concerned is conducted for determining the eligibility of candidate for teacher post class 1 to 8 in the central government school such as NVS and KVS and other schools. It is stated that the state of Jharkhand has formulated its own teachers eligibility test rules of 2019 dated 4/10/19, which apart from math, science, social studies teacher stipulation for language teacher, the rules further prescribe for eligibility of teachers imparting education of regional language, other local tribal languages for the preservation of culture, needs and diversities of the state. It is stated that Jharkhand Teachers Eligibility Test Rule 19 prescribe for different eligibility criteria with respect to appointment of language teachers who are required to have qualification at least one local language out of various local and tribal languages spoken in the state. That also, my lord, would answer your lordship. One, either the regional or tribal, my lord, only.
That the rules provide.
Yes, that is stated that Jharkhand Council of Education Research and Training Ranchi is responsible for performing the important function of promotion of education research, improvement of educational technique, practices and such, finding development, curriculum, instructional and exemplar material, method of teaching, techniques of evaluation, teaching data. It is stated that the Jharkhand Council of Education Research and Training, apart from aforesaid activities, publish and distribute books for regional and tribal languages free of cost, etc. Further stated that there are enough numbers of JTT qualified candidates within the state and hence allowing CTT qualified teachers in the vacancies of the state-run school is called prejudice. Stated that there can be no doubt about the fact that the ultimate beneficiary of the recruitment process would be a large number of children within the state who would suffer if there is undue delay in the appointment of teacher. However, the state is at liberty to set the qualification, particularly when these qualifications are in accordance with the statutory guidelines framed by NCT. Please mark this sentence, my lord, that it would be for the state to decide which, my lord, test is to be permitted, because that is the domain of the state and that is also, my lord, recognized and acknowledged in the NCT guidelines. It is further stated that petitions contain and place reliance on clause 10B of the guideline for conducting teachers eligibility test, which provides that TET conducted by state government with legislature shall apply to a school.
You complete this, there will be.
Yeah. School of the state government UT with legislature and local authority referred to in subclause 1 of clause N of section 2 and a school referred to in subclause 1 of clause N of section 2 of RTL. The guidelines further provide that a school at 1 or 2 may also consider eligibility of a candidate who has obtained TET certificate awarded by another state UT with legislature. In case a state UT with legislature decide not to conduct a test, a school at 1 and 2 in the state UT would consider the test conducted by the state government. That it is further stated central TET qualified candidate qualifying TET by another state can only be considered for a state-run school when the particular state government has decided not to conduct its own test. Submitted that it's not the case of the state government has decided not to conduct the JTET, and these circumstances state government is not bound to consider central TET or a candidate qualifying TET by another state UT as eligible qualification. The CT qualified candidate can be made eligible in a given contingency where the state government is not conducting TET, but when the contingency does not exist, there is no occasion to make central TET candidate eligible or to allow those candidates who obtain TET certificate from central government or any other state. This is submitted that there has been certain contingency due to which regular JT examination could not be conducted regularly, and hence the state is intending to allow age relaxation to the candidate for upcoming vacancies. Moreover, it is also intended to conduct JET examination before start of fresh recruitment of teachers within the state. Stated that issue whether to consider CET or TET from is a matter of policy decision of the state government. I have read and understood, so that is.
But before this date, the advertisement had been issued.
Before this date of filing this affidavit.
So this is 14th August.
14th of August.
July advertisement was there.
Advertisement is issued on 9th of July.
July.
Yes, your lordship is right. I'll come, lordship.
We'll come back. In fact, just